Miss Naila Awan. She is the senior counsel at Demos. Demos is a public policy organization in New York City, and they work to achieve pro-democratic solutions. Miss Awan is a graduate of Ohio State College of Law, and she works to address practices and policies in individuals' ability to engage in voting. She is going to present on state voter roll maintenance practices, and I hope that you enjoy and learn from her presentation.
Hi, everyone. So as Sean said, I'm here today to talk about state roll maintenance practices. Getting the day off started with a really exciting topic. But, you know, there are things that come into the news oftentimes when there's large-scale removals from the registration rolls known as voter purges. Just as like context, my essay focused on change of address roll maintenance. So it's like a limited sort of type of removal that we're talking about in that instance. And I'm not going to be able to get into all the ins and outs that I covered there just based on time. So just bear with me, and I hope I will have some time to answer any questions that remain at the end. Now, just for some background, by World War I, most of the US states had adopted voter registration procedures, and those procedures include both procedures to get people onto the registration rolls, how people can become qualified and registered to vote, and also procedures for removing individuals from the registration rolls when maybe their qualifications have lapsed. Now, those laws were used to both address corruption, but they were also had the impact of sometimes intentionally limiting participation of certain groups, whether those were individuals who were people of color, working class, or poor voters. And so even after Congress adopted the Voting Rights Act in 1965 to help address discrimination in voting, problems still remained. And so in response to the low voter turnout in the 1998 presidential election, only about half of the voting age population participated. And based on a finding explicitly made in the MVRA that discriminatory and unfair voting laws and procedures can have a direct and damaging effect on voter participation in elections and particularly impact certain groups such as racial minorities, and also noting that failure to be registered was the reason given by most eligible citizens in 1993 for not exercising their right to vote, Congress passed the MVRA to, among other things, establish procedures that would increase the number of people on the registration rolls and also restrict how and when people may be removed from the rolls. So there are a number of provisions in the MVRA that are designed to help meet these goals. And for one thing, the law puts forward various situations in which states have an obligation to provide voter registration services when people are engaging with DMVs or public assistance offices, for instance. Section 8 of the MVRA, which is the one most relevant to today's discussion, restricts how and when people can be removed. And specifically, it limits removal to those instances when individuals have either affirmatively requested to have their names removed from the registration rolls or when they've become ineligible by reason of criminal conviction, mental incapacity, death, or a change in residence. And for those last two types, death and change of residence, states are actually required to have a program in place that is designed to make a reasonable effort to identify people who've become ineligible on those grounds and remove them from the registration rolls. Programs for death and change of residence have to meet certain criteria. They need to be uniform, non-discriminatory, and in compliance with the Voting Rights Act. They may not result in the removal of an individual from the registration rolls by reason of their failure to vote. And for instances where states are dealing with removals based on a perceived change of address, they must follow a specific notice and waiting procedure, and they may not result in the removal of people within 90 days of a federal primary or general election or federal election. And just to give a little bit of context on what the notice and waiting procedure process looks like, the notices have to meet these very specific requirements. They have to tell people that they will be removed if certain actions are not taken. They have to give people the date by which they have to respond. And they have to kind of outline how people can remain on the registration rolls. Once those notices are sent, then there has to be a time frame that's before a person can be removed. So a person, if they do not respond to the notice, there have to be 2 federal general elections that pass before that person can be removed. It cannot be an immediate removal. And those requirements were really put in place to help both keep the registration rolls up to date while building in a safeguard to account for the fact that information can falsely identify a person as having moved. For example, in the NCO or in the MVRA, there's actually a kind of model change of address roll maintenance procedure that's put forth, and that involves using the U.S. Postal Service's National Change of Address system to identify individuals who may have moved, so people who've actually submitted changes of address to the U.S. Postal Service. Even when that information is received, because that data may not actually reflect a permanent move, the notice and waiting period still has to be used, so there cannot be immediate removals in such instances. Now, there are a number of ways that states can potentially run afoul of the MVRA's requirements in Section 8, as well as other federal laws, such as the Voting Rights Act or the Equal Protection Clause, to name a few. And we don't have time to go into every single way that all of those violations could occur, but what I thought might be useful is to look at a case that actually went up to the Supreme Court last year, Houston versus A. Philip Randolph Institute, now known because it's still continuing. How did that happen? I don't know. Ohio A. Philip Randolph Institute versus LaRose, which actually looked at change of address roll maintenance procedures and reflected on what it meant to limit removals or prohibit removals based on a person's failure to vote. So also just for transparency's sake, I am counsel in this case, so I feel like that's important to say before I continue on in talking about it. So in Houston, the issue that was at stake was Ohio's supplemental process and various procedures surrounding it. And Ohio's supplemental process basically uses a year of 2 years of voting inactivity as an indicia that someone has moved. So if someone doesn't go out to vote for 2 years, the state assumes that the person has likely moved and sends them a notice that starts this notice and waiting procedure. So what does that actually look like? This is kind of how it's set up, okay? So a voter doesn't vote for 2 years. Pursuant to a Secretary of State directive, that voter is then sent a notice by their county board of elections. If they don't respond to the notice, but they do vote within the next 4-year period, they stay on the registration rolls. Similarly, if they respond to the notice, say, hey, I still live here, they're kept on the registration rolls. If they do not respond to the notice and do not vote in the next 4 years, they're removed. And if they respond to the notice and say that they've moved, they are also removed from the registration rolls. Now, this last kind of set of circumstances, the place where a person hasn't voted for 2 years, they get sent a notice, they don't respond to the notice, they don't vote in the next 4 years, and they're removed from the rolls, is basically those instances where inaction alone resulted in a person's removal. Right? And what we were seeing was that numerous individuals, including one of our individual clients who had lived at his same house in Ohio for well over a decade, but had not been particularly motivated by the political process and the candidates and wanted to go out and vote, and also similarly had had some family issues and did not appear at the polls to vote. When he went to go vote finally on a ballot measure in 2015, he showed up to learn his name was no longer on the registration rolls, and there was no way for him to correct that. So he was completely denied his right to vote in that election, despite the fact that he had never moved. And this was happening for thousands of voters across the state. So in terms of the claims in Houston, there were two. One, that the use of non-voting to start the supplemental process violated the MVRA's prohibition on removing an individual from the voter registration rolls by reason of that person's failure to vote. And the second claim was that the notice itself actually did not meet the specifications set out in the MVRA, and therefore any removals that were conducted without individuals having received an MVRA compliant notice were also unlawful. And basically, just to give a quick glimpse of what some of those issues with the notice were, without going into detail about all of them because they are very dry and detailed. One of them was actually the state was saying you may be removed instead of you will be removed if you do not take this action, which doesn't actually give people necessarily affirmative notice of what is going to happen. It didn't provide specific details on what dates people needed to respond by. And also, it didn't provide out-of-state voters with notice as to how they can remain eligible. And it had to provide all voters with information on how they could remain eligible pursuant to the terms of the MVRA. Interesting, the out-of-state voters thing is the thing that all of the justices at the Sixth Circuit agreed on. So what happened with these claims? Claim one, that's done. That's what the Supreme Court decided. So the district court in Ohio decided in 2016 that the supplemental process was fine, that you can initiate removal based on someone's failure to vote. The Sixth Circuit overturned that 2-1. It said that that process actually violated the NVRA's prohibition on removing someone on the grounds of their failure to vote. It then remanded it back to the district court. And the reason I'm talking about the remedy issued at the district court is that remedy still in place with respect to the second claim. And it's also something that I think is a potential policy that could be implemented to address when people are removed from the registration rolls erroneously on any sort of grounds. And so what the district court did was it ordered a preliminary or a provisional ballot remedy that stated that anyone who had been removed from the registration rolls in or since 2011 who continued to reside in the county where they were previously registered, so they would have been able to update their voter registration at the polls, who appeared in person to vote, and who had not become disqualified for voting on another ground subsequent to their removal. So they didn't have a felony conviction, or they hadn't been found ineligible by reason of mental incapacity after the time they were removed, should be able to cast a provisional ballot and have that ballot counted, because the state had the information in their database to identify those individuals as people who had been removed on change of address grounds. Previously, what had happened was those people were not always offered, but should have been offered provisional ballots. Those provisional ballots were not counted, but they served as re-registration forms, which oftentimes put the people on the rolls right at the same address where they had previously been registered. And so in November 2016, that actually resulted in the counting of more than 7,500 provisional ballots in Ohio. When the Supreme Court took up the case, it granted cert just on claim one, so just on whether non-voting could be used as a trigger for sending this notice. It held 5-4 that it could. It held that actually having that notice and waiting procedure in place was enough, that protected the process, and that meant someone was not being removed on grounds of non-voting alone. Justice Sotomayor, in her dissent, noted that there had been a study in Ohio that had indicated that in one county, the individuals, and there wasn't a statewide survey done in Ohio, there was a one county analysis, individuals who were in the African American majority downtown neighborhood were removed, 10% of the voters were removed, versus individuals in the abutting majority white suburban neighborhoods where 4% of the voters were removed. She also kind of looked to the amicus briefs that had been submitted in the case, and she noted that the amici had explained how low voter turnout rates, language access problems, mail delivery issues, inflexible work schedules, and transportation issues, among other obstacles, actually made it more difficult for many minority, low-income, disabled, homeless, and veteran voters to cast a ballot or return a notice, rendering them particularly vulnerable to unwarranted removal under the supplemental process. And what this and other portions of Sotomayor's dissent really point to is the fact that using non-voting to initiate purges could, depending on the circumstances, depending on the data, actually lead to the process being subject to challenge under either Section 2 of the Voting Rights Act, which prohibits use of a voting practice or procedure which results in the denial or abridgment of the right to vote on people based on race or color, and the 14th Amendment of the Equal Protection Clause. Kind of shifting gears back to Claim 2. So in 2016, the District Court held that most of the notice claims were mooted by the defendant's action. So except for the issue I discussed about out-of-state movers, the state had actually changed its form during the course of litigation, and the court found that those changes just mooted all of the claims and nothing had to be done for anything that had happened previously. The Sixth Circuit, when it took that up on appeal, actually held that those claims were not moot, and it noted that the defendant had also failed to meet its obligation to provide out-of-state voters with the notice required. And interestingly enough, that was actually the one issue, the out-of-state voters issue, that got all three of the justices on the Sixth Circuit to agree. After the Sixth Circuit's decision came down in 2018, the parties re-engaged in litigation on the second claim. So all of the issues about whether the notice was still the claims that had not been mooted, what the appropriate relief was there. And the district court sided with the defendants, finding that there had not been a violation of the remaining issues. An emergency injunction on appeal was taken, and the Sixth Circuit reissued the APRI exception for the November 2018 election, finding that that was appropriate relief based on the notice claims. Now, one thing to note is that the APRI exception now, either through joint stipulation or court order, has actually been in place in every single Ohio election to take place, whether federal, state, local, or special, since November 2016. And it's something that the state has actually indicated that it can easily administer. So just to kind of encapsulate some of the change of address issues, as noted earlier, the Voting Rights Act and Equal Protection Clause can be used to challenge potentially discriminatory voter purges. And we talked about that in the terms of non-voting, just to give context of what one more of those situations looked like. Back in 2015 in Sparta, Georgia, the local board of elections actually dispatched deputies with summonses commanding approximately 17% of the electorate to show up at a hearing to prove their residence or lose their voting rights. And almost all of the people targeted in that instance were Black. So that's another instance where we might see a possible VRA or EPC challenge to actions like that, right? Then there's also those, in addition to the challenges around sufficiency of notice, are not the only things that might come up. There's also things around failure to send notices or follow the notice and waiting requirements, failure to meet uniformity requirements, and removals within 90 days of a federal election, kind of all requirements I set out earlier. I'm just going to briefly mention two cases which kind of tie to some of those different issues. So in Common Cause v. Lawson, it's a case in the Southern District of Indiana. What Indiana did was it had been using the cross-check program to identify people it thought may have moved. And then it was sending the notice and the notice required and waiting the required time before removing people from the registration rolls. Indiana changed its law. And Indiana tried to say that information from the cross-check program could be used on its own just to remove people without ever having to send a notice. So it also was then failing to provide county boards of elections with information about how to implement this process. So it wasn't actually telling them how to identify whether information that was of individuals on the cross-check list and information of individuals who were in their elections database, how to determine whether or not they were the same person. It didn't give them like matching criteria or anything like that. So it was actually being implemented unevenly across counties in terms of looking at cross-check. And so with respect to those two things on a preliminary injunction motion, the Southern District of Indiana actually said that that violated the notice requirements of the MVRA, and it also failed to meet the uniformity requirements. With respect to also the notice requirements, but also the 90-day requirements, there was a case that came up in 2016 in North Carolina. And in that instance, what we saw was there were 3 North Carolina counties that were sent the names of about 4,500 voters. These voters were being challenged by private individuals who had sent out mass mailings, received bounces, and then sent the information to the county board saying you should purge these voters. And that was happening within 90 days of the election, and people were just being removed. And the court found that that not only violated the failure to provide the notice required under the MVRA, but also that it was unlawfully removing people too close to the election cycle. So this other issue is kind of like beyond the scope of what I wrote about, but just something I wanted to flag, because it's worth noting that there are problematic removals that have been kind of making the news and are in other areas outside of change of address. And what we've seen recently is in both Los Angeles County and in Texas, there's actually been information that's been being used that is erroneously identifying people as ineligible by reason of felony conviction or by reason of immigration status, either because that information is stale or it is just showing people who've come into contact with the courts and not distinguishing the fact that they have finished their term of sentence and have already been become eligible to vote again and re-registered, and then stripping them from the rolls again in California. And so there's actually cases going on these two issues right now. The Texas practice has actually been halted. It was using kind of data that was very stale and didn't indicate whether someone had become a naturalized citizen since the previous time that they'd interacted with the motor vehicle agency. So one of the things I think that like in the change of address realm, in the, immigration realm, in the felony disenfranchisement realm, one of the things that is clear is like the importance of using good data, right, to conduct roll maintenance. I think that that's one of the things that it's just become a problem again and again. And also the importance of having certain fixes in place to help prevent individuals from being disenfranchised if they've been erroneously removed from the registration rolls, because really those people did what they needed to do to register, right? They met their obligations in that end, and they shouldn't be being penalized because the state has made an error. And so, I think that there are some back-end fixes and some kind of pro-voter reforms that can help meet those goals. One, in terms of back-end fixes, is allowing voters to correct their registration information if they find out they've been removed, even if it's after the deadline. Of note, in Ohio, you can already do that if you're erroneously removed by the state's belief that you've died or become ineligible by reason of felony conviction. It just doesn't extend to all the different types of removals. And then, allowing voters to cast a ballot or have their provisional ballot counted if the state's able to determine that the voter was previously registered in their jurisdiction and was removed based on an erroneous belief that they were disqualified. And that, for instance, would be something like the APRI exception if we're talking about provisional voting, something which the state itself has said is administrable and easy to conduct as part of the general provisional ballot counting process, since you're already looking at the voter history and voter file. And then, things like pro-voter reform, same-day registration, offering the ability to both register and vote at the same time. It's been adopted in states since back in the 1970s, right? It's something that states have a practice around. Automatic voter registration, increasing the number of designated voter registration agencies in a state, and also adopting online voter registration. And I will say, I am by no means an expert on the processes used for all of those pro-voter reforms. I do not know the ins and outs of each. But, you know, one thing I will say is the legal requirements for roll maintenance have been established to provide protections to voters. And it's essential that those requirements not only be met, but that accurate information is used to initiate removals. And because no practice is perfect, recognizing that policies need to be in place to prevent voters from being disenfranchised when they are erroneously removed from the rolls. And then I think I have some time for questions. Okay, 5 minutes for questions. Yeah.
Could you briefly describe and mention any relevant cases you're familiar with, the practice of caging, and also could you address efforts that I have read of in various places that have made use of the very good statistics that are out there now that enable identifying race by surname and by first name? I think may have been used in Florida.
So in terms of voter caging, actually, you know, I feel like that actually has kind of a wider array of like references to it. The North Carolina case I was referring to, which was where like individual citizens had actually sent the bounce back notices and then provided that to the state boards of elections or local boards of elections to purge people. That's actually one of the circumstances. It's kind of known as voter caging, and that was, they changed the name of the North Carolina Board of Elections. So it's the North Carolina State Conference of NAACP versus the Bipartisan Board of Elections and Ethics Enforcement. And I'm sure that there's some inside of like the at the polls challenges too, if that's kind of what you're thinking of, but that I'm not familiar with those cases. And in terms of the race data, you know, it's interesting because there are a lot of kind of algorithms out there and stuff where, because you can't find out what it is because it's like intellectual property, it's hard to use that in cases necessarily. What I have seen done, and what we actually did on a Section 2 lawsuit I was involved in Ohio, was going down to census block track data, which was pretty useful because actually the U.S. is still very segregated, right? And so I'd say 90% of the census blocks in Ohio were homogeneous in nature. And so that allowed you to actually determine what the impact was based on race in a really useful way, and in a way that was transparent to the court and able to really assess the expert reports. Anything else?